Hey there, my name is Jason with inheritedland.com and welcome today. Thank you for watching this video. I have a special guest with us today to talk to us about all things inherited property. Welcome, Al Nicoletti. He is, besides being a stand-up guy, he is the top probate attorney in the state of Florida with the law offices of Al Nicoletti servicing the entire state. So welcome to our program today, Al.
Jason, hey, thanks for having me. I'm happy to be a part of this. I'm happy to contribute and provide value to people out there. So I'm just happy to be here.
Awesome, awesome. So as with the theme of many of our articles, blogs, and other videos here on the website, maybe our audience today, most of the time, are probably looking at this material because they've inherited a piece of land. So a typical question that myself as a land investor, a land buyer, often has with people that say, Jason, I inherited some land. It usually goes something like this. There are several different ones, and I want to just ask you them today, ask the expert and get your opinion. But a common one I get, a case in point, it's probably happened 10 times over the last year is, Jason, my grandpa, mother, father, some heir passed away. They own this piece of land. Okay, so usually it's 20 acres somewhere off the beaten path. Maybe they owned it. It's undeveloped most of the time, and they own this property. I inherited everything else they had. I've been paying the property tax bill sometimes for years, but I'd like to sell the property. Can I sell it to you? So the first question we usually ask is, was the property deeded to you? But there can be a little confusion over that. What's the difference, Al, between paying a tax bill for a deceased heir's property and you having the rights to sell it? What needs to happen in order to be able to sell a piece of property like that?
Yeah, there are several times when I'm on the consults that the heirs, they talk about, hey, but I've been paying the taxes for 15 years. Mm-hmm. That all aside, the big principle is, in Florida, we have to do probate. So there's two reasons why we have to do probate. First, title insurance to get the property sold to a buyer will require it. And two, Florida is a judicial state, meaning we have to go through court to judicially confirm that you are the heirs, that now you are entitled to this asset, and now after that, you can do what you want with it. And a lot of times people are surprised by that because, South Carolina, North Carolina, some other states may be different. But when you're in Florida, we have to do it. What probate is doing is transferring the title of the asset that the deceased person owned to who the true heirs are. So what we're really doing is a transfer of title over to those heirs. And once the process is over, now they have title, can sell it, convey it, and get it to you. So when you ask that question, I mean, how do we get it sold? If the heirs say, well, how do we get it sold to you? Or, can't we just close and do this later? We got to do the probate part first because the title insurance is going to require it. When we get into those tax questions, because when they say, hey, I've been paying the taxes for a long time, it's a really tough angle because to try to get either reimbursed or to try to claim that they get everything it's an uphill battle, especially with the kind of assets you deal with. Land, there's really tight numbers. Not to say that there couldn't be a route that they could get it, but it's hard. What is preferred is you get the probate done. And then at the title company, the title can put together a piece of paper allocating the money and saying, hey, if everybody agrees that the heir that's been paying the property tax gets this portion, you all get this portion, it makes things so much easier. So to just answer it, it's really just a simple process to move the title over.
So long story short, you cannot sell any property unless you have the title in your name. So you can't sign to sell that if it's in a deceased person name, whether it's through probate, or there are a few exceptions like affidavit of heirships in other states. Some sort of legal process has to happen to move it from the deceased heir's name into yourself as the only heir, or if there's other heirs involved, onto title, where then it can be signed over for a sale, correct?
Correct. That's what we have to do. We have to get paperwork filed in court, because the thing is, there has to be documentation laying this out. Like, we got to show the death certificate. We have to show who the deceased party is. We have to show who the heirs are or heir. We have to show what the asset is. And we're filling out all this paperwork and filing it in court, and then sending in court orders for the judge to sign.
Gotcha. So clarify for me two terms that are commonly used here. I know we have a glossary of terms on the site, but kind of wanted to hear it. People say, the person, did they die intestate, or did they die right with a will? So what does intestate mean? Just that they didn't have a will when they
Right.
passed away?
Yeah.
Okay. So what's the probate process look like if the person didn't have a will and they died and you're the heir?
It's really similar to if they had a will versus they didn't have a will. There's still paperwork that has to be filed. The difference is, if there's no will, we're not saying that there's a will. And some counties may want an affidavit of heirs. They want along with the probate, but there's certain requirements that come with intestate probates. It just means that there's no will. You need everybody. Everybody's got to be on board to participate. The will, that's a different mechanism, because in Florida, we need the original ink will. And I stress that because even I had a consult today, and the heir said, I sent you the original will. I said, in PDF. We need the original physical ink will. And so that's where this kind of branches off into two good points. She said, well, the probate was already done in another state. I said, okay, so the will is in the other state. She said, yes. So a lot of people will think, oh, well, wait a second. If it's been done in New York, or we did it in another state, why do we got to do it here? We still got to do it in Florida. And this is the interesting point. Right, because the property's here in Florida. Here's the interesting point. Whenever you have those kinds of cases where the will is in Oregon, Ohio, New York, California, wherever it is, we still need that certified copy or exemplified copy of the will, and the court order admitting the will, really the entire file, exemplified or certified copies of the entire file, and the certified copy of the death certificate. And this is a great point, because this helps people in advance go, wait a second, we have to gather all these documents. There's things that we gather. So I kind of like the cases where there's no will, because now they're not having to take the extra steps of having to go to the courthouse, having to contact their other attorney, or going to try to find a safe deposit box, or trying to scramble and find out where the will is. Because then if there's no will, it makes it cleaner. But sometimes the will's going to one person and there's 7 kids. Sometimes the will leaves it to a trust and not people. So the process is while relatively the same, is a bit different in terms of the direction of where it can go.
Okay. So I believe I've heard the term in similar situations, ancillary probate. Now that's just where the person died in New York. Let's say they had a house and a business and some assets there. Their children maybe live there in another state. They probated the will there, but they had that piece of land they were going to build their vacation home on in Florida. And they decide, no one's going to build a vacation home now. We want to sell that. So in that case, they have to then probate it in Florida as well. Is that what an ancillary probate is?
Right. Yes. So when they call it domiciliary probates out of state. So like when it's been done out of state, let's say Georgia, South Carolina, North Carolina, any other state outside of Florida, it's happening in those states. And all of a sudden we find there's an asset here in Florida. The type of probate that we need to do is ancillary, almost like secondary to the primary probate. It's just a term of art. It's just what we call it. There could be different implications in terms of things that we need to deal with in the probate, but overall, it's just a term meaning like it's secondary to the primary.
Gotcha. Okay, so this is part of the process, and obviously, I'm assuming a probate is not something a person can do themselves. They need to contract legal services to do this process to make sure that it's done right. Is that correct?
So what's really critical, especially getting the attorneys involved, is getting the inheritance line correct. And
Mm,
that's where it can get really tricky, right? So a lot of times somebody may go, well, I'm the only heir, I'm the only surviving heir. Well, in my world, in the attorney world, we know, wait, it's not just about surviving, it's heirs ever. It's how
mm,
many heirs are there ever? And so in my world, we're doing a full analysis. So you really want the professional to come in to really analyze, because you don't want to mess it up. You don't want to have a situation where there's other heirs that are missed, or the other crazy one, Jason, is multiple probates.
mm.
Sometimes grandma will die, and then there's two kids, and then it's brother, sister, and then the brother died after grandma. And then we're doing a second probate. And some people say, wait, we're done. We just did grandma's probate. And then we're having to do brother's probate. So the
Mhm.
analysis is really key to analyze. The inheritance is really key.
So basically, if I'm understanding you right, the inheritance goes down the family tree. And so let's say there were a couple of her siblings, they've passed away, I'm the only one alive, but they might have children, they might have grandchildren. That heirship or their portion, let's say there were three children, the property was heired to because the parents passed away. Those three heirs have that 33% right to the property, as do their descending lines. So just because they passed away and I'm the only one alive doesn't mean that there aren't heirship rights that go down that line. So you're going down those lines, investigating, making sure. I mean, this has to be done right so that title can be clean, which is what you were talking about. A title insurance is basically they have to guarantee there's clean title, because if there's a cloud or some sort of a doubt in that, the property potentially could have no value or not be able to be sold in the future, right? So this sounds like something that not only do you want a professional to do, you want to make sure that it's done completely right.
Right. And some of the estates in counties have different requirements. Some get really picky about what they want, what they need. In my firm, we go all over Florida. And so we're seeing every county's requirements. Like
Mm,
Palm Beach County wants everything notarized. Some
mm,
other counties don't.
mm,
Some counties don't even need an affidavit. Some just want just a signature. Some require original death certificates, even of the pre-deceased spouse. So just because you fill out paperwork, or we get paperwork filled out, there's other things we need to get and gather. And that's
mm.
why I even put together my own probate checklist that helps heirs whenever they come across this, to say, hey, before I get with the lawyer, I got to get all these things together,
Mm.
right? Like,
Yep,
for
same
example,
time.
yeah, it saves time. It's efficient. It's about efficiency, right? So the probate checklist is huge, and it's like I'm speaking at all these events, like saying, hey, here it is. We're always looking for all the heir info, all their contact info, names, mailing address, all that, right? Email address. Also, what's key is the property address. Is it one lot? Is it 5 lots? Is it a house? We need to know the address. Another thing is the death certificates. Anybody that pre-deceased or post-deceased. Another one is any will, any trust. Is that, where is it? At least you got to see it, right? Also, what's really important is the title commitment. A lot of people will say, yeah, but the person died and we got to do probate. Well, how do we confirm that for sure? And that's where the title underwriter issues that title policy commitment. And that's where it says, hey, you need to do it. Or it may say, hey, you don't need probate here, right? So that's another big one. And if you're selling the property, where's the contract? Where's the copy of the deed? So I talk about this now because these are time-saving things that you can gather ahead of time now, and not wait later and say, oh, I wish I would have had that.
That's a great point. And I want to jump in here just to those that are watching here today. So the contract, copy of deed, and title commitment, those are three important points that myself and my team, if we decide to buy the property from you and work with you in this, what basically Al is saying is there's going to be a contract, a sale agreement, a purchase and sale agreement that says, you as the heirs have this property, and we as the buyers want to buy that property from you as land investors. And usually then we take that contract and send it to a title company, and they do a title research, their title examination, their researcher does. And the commitment is actually a document from the title insurance company that says, yes, we can insure the sale, or no. And really, they're kind of the top thing because they're taking the risk to say, if there was an issue, we're going to run the risk. And once it's insured, generally speaking, you're good, because if one company will insure it, the next will insure it in future sales. And so they're going to be very scrutinizing when they do the research and give you a list of requirements on a schedule in that title commitment, which is what Al needs in order to go, oh, they have to have this fixed, or they have to have this fixed. Or like you said, maybe we don't. So one of the first steps is for us to always look at the property, run it through our title company, come to an agreement, and then we see, okay, how do we do this process? I did want to ask you, Al, another question that we find a lot. You mentioned sometimes other probates. I know we had a recent case with a woman who had a ranch in Texas, and it was a situation where she's 80 years old. She owns 4/5 of the ranch. It was actually deeded to multiple people. She bought out from some aunts and uncles and had, warranty deeds for 4/5 plus her, I think it was her dad, and left her a part of that. And then there's one cousin who owns the other fifth, who we were able to track down. But when we went back to title, it was her grandfather's property, and he had never probated his will, nor had several of his deceased children. And so there's some in there, even though one of the aunts had actually deeded her the property, they want us to find and see if she had probated her will or what happened, because they want to make sure that she had the right to deed the property. Was she married? What was going on in her situation? Do you find situations like that where you have to go back generationally and fix things? And how far back do you go, and how complicated can those be?
Well, the answer to the last question right there is it depends on what underwriting wants. If they want probate to go way back when, and we saw one where they wanted a probate of somebody from 1945. So it's really what the underwriter is going to want to satisfy any title insurance requirements. That's the first one. But yeah, we've seen ones that go way back. I had a crazy one where it was up for tax deed auction, and it was going to auction in like 3 days, and it just landed in my on my desk, and they said, hey, we need an analysis today because we need to see if we can do this. And it was crazy. Did the whole analysis. Ultimately, there ended up being 3 people total, 2 heirs still alive, but that's really who we needed. When we looked at it, I had to do 6 probates because the person that owned that property bought it back in like 1930, died in 1950, and half of that property was owned by him, and nobody ever did his probate. So when you talk about generations going back and doing it, when we looked at it, we had to do his probate. There was somebody from 1970, 1980, 1990, 2019. I mean, so many. But when you get those, the ultimate question is, do you even have enough room in the deal to be able to make anything off of it, right? Like if you're an heir out there,
the cost of the legal work.
yeah, because I mean, that's going to be very expensive. It was a very expensive adventure to get everything, to search, the skip tracer, the investigator. Ultimately, I can't remember what they came out with, but if that ends up being your situation, you want to know, am I even going to come out positive? I mean, 6 probates sounds like an adventure, but at the end of the day, everybody's got to come out positive, and it's expensive. So it's possible to get those done. Jason, I almost had one about a month ago, and there was a lot of equity in the transaction. I mean, the sellers would have made a lot of money. but it was going to need 8, maybe 9 probates. And I told the sellers that, I told the buyer that, and they were like, let's do it. Let's do all 8. I said, if you find everybody, come to find out it went up for tax deed auction like 2 days later. So there was no time to do it, but no problem doing those.
Hmm. So you mentioned there multiple probates going back. What's the use of a quiet title? We hear about we could do a quiet title suit to quiet title if there are some sort of issues. Is that something that a person can do in a situation where these would be too much work to fix? Or does that not fix that airship issues at all? How does that typically work out? Or what cases would that be used on?
Like a quiet title as an alternative to doing the probates.
Yeah, I mean, we hear people talking about that. Is that accurate or not?
It doesn't happen as often as you think. Like, it's very rare to be able to use the quiet title in the event of deceased people that are in the chain. For tax deeds, that's one thing. On tax deeds, where you buy it at the auction, or you got a quick claim deed from somebody that had a tax deed, maybe there's deceased people on title, sure. But if it's just a regular transaction, many times title insurance won't even let you do the quiet title for primary residences. Quiet titles basically are a lawsuit to serve any people or entities or liens, judgments, anything that may have an interest in the property, to serve them with the papers and have them come forward. And if they don't come forward, eventually they're wiped out. The thing is with quiet titles, they are expensive and they are long. They can end up being 6 months to a year, maybe sometimes longer. And they can end up being like $15,000. So they're expensive, but they can be useful. Some examples: clearing up a legal description. Sometimes somebody used the wrong legal description from the property appraiser in the deed. Another one is a wild deed. Sometimes there's some like fraudulent activity that goes on with deeds, and maybe a great example, Jason comes across your property and finds out that somebody randomly recorded it, but you're the one that's entitled to it. That could be a wild deed. That could be subject to quiet title. Even other examples, just things in the back chain. Maybe there's old judgments. Maybe I had a case, 3 years ago, where there were credit card judgments, like old judgments, more than 10 years. We served them, we got it done, we wiped them out, that was it. So there are useful ways for the quiet title to be used. It comes down to timing and money involved in it.
Yeah, for sure. Another situation we often get is we find people that have inherited, and this might not be that common in Florida, I'm not 100% sure, but particularly in states that have some sort of mineral rights that can go with the property, we'll find people where they've inherited basically a small percentage, usually an undivided interest in the property. So you see some states are really common with that, and they'll have a 1% interest or a 30% interest, a 10% interest. But if it's a larger percentage, usually it's fairly simple to figure out who's who. But sometimes they have a very small percentage with multiple owners out there. In some cases, like I said, we've seen it in Texas and a few states that have maybe oil or gas. Whereas my thinking goes, great grandma or grandpa, they handed down to their heirs undeveloped land, hoping that maybe someday there will be some gas discovered or oil discovered on it for their heirs' use. Whereas if that were to happen, the heirs would then all get some royalties. But in this case, it hasn't happened, and they're wanting to get rid of the property, but there are several heirs on the property, and they're not necessarily all close either. So maybe it's distant cousins and whoever else has bought and sold and got into that. I find a lot of people that want to sell those, we can't do anything with an undivided interest, because according to my understanding, an undivided interest is that you own that percentage of every rock and grain of sand on the property. So it's not like, 10 acres and I own a tenth, I own an acre. It's actually, you own 10% of every little tree and bid on the property, so you can't really develop the property or do anything with it. What's a situation like that? Is there a way to clean that up? Is there a way to do a partition suit, or how could that be sold, or is that just something that they're probably stuck with?
So I don't really see anything with the oil, gas, mineral stuff. So just starting point, like I never see that. It must be more of a Texas thing. I mean, maybe there's parts of Florida that deal with that, but in terms of like where you're going with partial ownership interests, right?
Mhm.
3 want to sell. There's 5 people on title. 3 want to sell, 2 don't. That's definitely something that has to be analyzed by the attorney, because there's so many situations that can come down to what you can do. Maybe you do a partition lawsuit. Maybe you sell your interest to somebody and let them deal with it. But whenever you get those, they have to be really analyzed, just like the quiet titles. You got to see due diligence. You got to pull the title commitment. You got to know what's going on. You got to know, is there equity? Is there a mortgage? Any liens? There's a lot more due diligence that goes into it. So partitions are a really interesting avenue, especially for people that they don't want to deal with their other family members, right? So what they'll do is they'll say, you know what, I don't want to deal with them. I want to live my life. I want to move on from my life. Jason, I'm going to sell you my interest. And then the other 2 chime in and say, oh, I want to sell you my interest too. So then you buy out the 3, and then you're left dealing with the 2. And then, hey, maybe you negotiate with the others and maybe you buy them out as well. But the same thing happens with partitions. They can be long, they can be expensive. There's a lot involved. So you definitely want to get with an attorney, schedule a consult to find out, you know, hey, what's the best route here? What are we dealing?
Thank you for sharing that point. A good point here to mention too, and this happens often as a land buyer. I'm buying parcels of land in multiple states every day. Is people often think, well, I have a beautiful piece of land, and it is a beautiful piece of land, and oh yeah, it has a market value, right? Obviously, a piece of undeveloped land is not as valuable as if it, was already developed with a beautiful house and outbuildings. But a plain piece of undeveloped land can have value. It can be very valuable depending on the location. But the more complicated the situation gets, that affects the value that I as an investor can put into it because all the legwork. So there's a risk factor, like you just mentioned. Sure, I do deal with a lot of that. And if that's the case of someone watching today, feel free to reach out, contact us. We'd love to talk to you. But we do deal with people that say, I don't have a lot of contact with my siblings. We had a falling out over this. I don't want to deal with it. I just want to wash my hands of it. There are situations where I've been able to buy that person's part, maybe get them to quit claim it to me. They're not going to get a premium for it, but then I'm taking the risk to try to track down the other siblings, negotiate with them, try to sweet talk them into selling or finding a solution. There are situations we do that, but the more work involved, obviously, there's a bigger investment on the buyer side and risk in that case, which leads me kind of to our last question here for this interview, Al, is what's the typical legal costs and timeframes to solve these? You mentioned things like a partition lawsuit for multiple heirs, or things like the quieting of title. Those can be very long lawsuits. It's a year, maybe more. But you mentioned probate is a little bit smoother. What's the average time to probate a person's will or without a will in order, let's say they have a property in Florida, they want to sell a few acres. What's that usually look like? And what's an average price range for something like that?
Yeah, so timing actually, and this is for probates, not for partitions and quiet titles, because that's a whole other ball game. Price and timing on those are different. But for probates, you could be looking at maybe about 3,000 to 5,000 per probate. Really depends on the county, depends on what we're doing, the situation. That's per probate in that range. And when I say per probate, because like we talked about earlier, multiple probates, now we're doing multiple probates, and it's not going to be the same price for all the probates. So you're looking at that. Of course, every case has to be analyzed. We could be dealing with the full-blown probate, the formal administration, not a summary. I've dealt with many of those with investors with the formals, and those are more than 5. I mean, you could be looking at 6, 7, 8,000 for that. But what's great about the price on that is, in my firm, we're able to wait until the closing to get paid. So while everybody's probably watching going, whoa, you know, I have to come out of pocket, everybody now has a fresh a breath of fresh air, where I'll wait until the HUD, the sale, to get paid if they're selling the property. If they're not selling it, obviously I got to get paid up front. But then the timing's great. That's probably the best part about all of this, is that a lot of people, when they look up probate, they see timelines, they see things online about it's going to take 6 months, 9 months, 12 months, 2 years. In my world, we're looking at a matter of weeks to a couple months. And a couple months is being like, wow, that took a while. You know, we can't help when a judge doesn't sign or takes a while to sign, or the county's got different requirements. We can't help that. Those are things that are just out of our control that unfortunately we deal with. But overall, in most, if not all the counties, we've seen a matter of weeks to a couple months. And I've seen a lot of counties. I haven't seen them all, but I've seen a lot. And timing's what's fantastic.
Well, that's awesome. And that's one of the benefits of working with a partner like Al Nicoletti in the law offices of Al Nicoletti. I wish, having bought and sold land in 11 states, I wish I could say that of all the law partners in every state, some of them aren't as motivated or as quick as you. Also, some states vary with their processes too. I know Florida is pretty digitalized and modernized in that, which definitely helps. That does, I think, take into account, though, Al, that they already have done the checklist, they have the documents ready to go, which can be kind of time consuming to go after. So a good thing, seller, beware if you are watching this video and you have inherited land, before you really get into this process of getting a title commitment and signing the contract to sell it and working with us to start this process, you need to go through and start getting your documents in order, right? Thank you so much, Al. This is super informative. And for anyone that's watching today, if you have vacant land that you're looking to sell, that you've inherited, maybe this process is difficult, you don't know how to navigate it, maybe you don't really have the funds available to go ahead and put up front, working with people like us here at inheritedland.com gives you the benefit that we have people that we work with, just like Al and his team and others across the United States, ready to help you navigate the difficult process and the paperwork, because one guarantee beyond death is taxes and paperwork in the United States of America. But if it's done right, you can have a successful sale of your land and enjoy the benefits of the inheritance that person, that loved one who passed away, would have wanted you to enjoy. All right. So thank you so much for watching. And thanks again, Al, for being here with us today.
Thank you, Jason. And to everybody out there, probate is actually a lot smoother of a process than you think, and work with the right professionals.
Awesome. Al's information will be here on the site, so you can reach out to him or his team directly. You can also click the contact us button and talk to my team and I, and we'll help point you in the right direction with the sale of your vacant land that you've inherited. Thank you so much.